Hi guys, it's Kathy. I hope you're doing well. Today is Tuesday. Yep, we're feeling the pressure. Yes, we are, Sandra. We are feeling the pressure. This week is when people are most stressed out and broke. And yesterday, me and my daughter went out and we just got everybody in one foul swoop. We just got everybody. One tiny little thing. Nothing big, nothing crazy, nothing expensive. We are going to go out to eat on Christmas. None of us want to cook. None of us feel like putting in the effort. It's too much. So we're going to a Chinese buffet. And we're not supposed to get any gifts. We are doing gifts next month. Because, it's too much to get everybody on one day. It's just too much. Yeah, you have all year to prepare. Yeah, I know. But we're getting, just certain people on Christmas. And it's not supposed to be anybody in our tight family circle. It's like our friends and nieces and nephews that we have to buy presents for and things like that. And then we do a Secret Santa where me, my kids, my niece, her son, my daughter's boyfriend, we all just pick one name and buy one present for one person. It's way better. Outstandingly better. My kids aren't children anymore. They're not tiny little children anymore. So they don't need to wake up to a pile of presents under the Christmas tree. So, I did go out yesterday and buy everybody one tiny thing, which is against the rules. But I don't care. Who's going to say something? I'm sort of the head. There's no one, can overrule me. I can overrule everybody. But no one can overrule me. Bobby, me too. Oh my gosh. I just don't know if it would feel good, if it would be very painful. Anyway. We are... Okay. You're going to be extremely disappointed. But... I have 5 short minutes of this. And no more. Everybody's going to want more. First, you're going to be mad about the audio. You're going to be like, I can't hear. I can't hear either. You think I can hear these things? You guys can't. I can't. But you're going to see why I'm going to play these 5 minutes anyway. We only have 5 minutes. 2.5 minutes of that is bad audio. The 2.5 minutes, though, is really good. I think there is... attack? What kind of attack, Bobby? What kind of attack? Like a rodent attack? A bear attack? A heart attack? A panic attack? A snack mac? Snack mac? Big Mac attack? I need to know. I need to know if you're in a lot of pain or not. Yeah, that is much easier, Monica. You had a seizure? You need to relax today. You need to sit back and relax. I won't play any flashing anything. Look, even my background is just gray. Gray. Alright, here we go, guys. Hope you're ready for this. I can't give you more than 5 minutes because that's... He stopped the stream. This is the senior judge of Chatham County, Georgia. Don't know his name. Come on, there we go.
I don't see the email that I sent.
Ah, darn it, there's no sound. Why is there no sound? Why was there no sound? Chrome. I see the problem. Cable B. There we go. Now we have sound. I have to rewind it because we only get 5 minutes. We don't want to lose any seconds of it. Here we go.
I don't see the email that I said that to you. I know I said that to you. Okay. Yeah, because the email that I responded to that was a very condescending email. You write in it, "That's a professional email. Well done. The kind I expect from a fellow member of the bar. I recommend we maintain this level of decorum in all future correspondence." So the email that you sent me was, yeah, pretty condescending. Well, the inference is that I had not been professional with you prior to that, and I don't understand why you would say that. We going backwards or forwards? Yeah, I said that before I called you the condescending prick, and it was after you wrote, "If your career at your father's firm doesn't work out, Saturday Night Live might be in your future." So you see there is an action by you and a reaction by me, and if what you want is a reaction, then you say things like that, and that's what you'll get is a reaction. You did, all of them, for some reason. Is that a question? When you shared the emails to the court, I responded to you privately and like, "Why did you do that?" Kind of temperament. So yeah, I responded to you directly, privately, after you forwarded our communications to the court for some reason, which I'm still not quite sure why you did. Yes, I think you're a highly intelligent person. You clearly are very articulate. You're an amazing writer, but you're extremely petty. Yeah, I said that.
Your Honor, objection. That is just inflammatory. He's, again, objection. There is nothing that has to do with race being brought into that. Mr. Swan is just making that leap.
That's it, guys. That's all we get. The judge shuts down the feed now, and we don't get any more, and I don't know why. I want to see this trial. This is the trial I want to see. We can't hear. He steps off the bench, and then that's it. There's no more. The judge is going to speak here. Judge doesn't have a microphone either, so I don't know what he says.
Mr. Phillips is counsel of record. Mr. Phillips is counsel of record in this case. I believe calling him as a witness, adverse or otherwise, would not be proper under the Georgia rules.
He wants to call the other lawyer. He just put something on his desk. Did you see that? I wonder what it was.
Your Honor, I did draft a proposed order for the court's consideration, if I can pass that up. Thank you, Judge. What did you say? He said, don't worry about it.
That's it. He's leaving. The judge is leaving. And then the stream goes dead soon. I'll show you. There goes the judge. The bailiff is making sure these two lawyers don't get into a fist fight in the court. Boom. Off there. Oh, I wish we could have seen that, guys.
State, would you please set our record?
Okay, this will be State of Indiana versus Kevin Robinson, 64 D01 1604 F4 3000. Defendant appears in custody in person with Attorney Shargaloff. State's represented by Deputy Prosecutor Hammer. I believe we're going to be set for a change in, or the change in disposition today.
Yes, sir.
Judge, I also have exhibits attached that I believe the state is taking.
Yes, Your Honor.
Thank you. Mr. Robinson, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
I do, Your Honor.
Okay, thank you. I have
Judge-
a one-page document entitled Recommendation of Disposition.
Judge Fish is my new toy. I don't know why. I keep going back to him over and over again. I feel like he has a banger content in him. I feel like if you make this man mad, whoo, you know what was that Falling Down, that movie Falling Down? I'm not going to say anymore.
The document appears to bear your signature down along the left-hand side. Did you sign this agreement?
Yes, I did, Your Honor.
I'm going to white out the signature next to probation officer.
Yeah, I apologize for that, Your Honor.
No, I just don't want anybody to quickly look at this and think the probation officer signed off. Did you read it before you signed it?
I did, Your Honor.
Did you have a chance to speak with your attorney before you signed it?
I did, Your Honor.
Before you signed it, do you think you understood everything in it completely?
I believe so, Your Honor.
As I understand this, you plan to admit all the allegations contained in the petition for revocation of probation, and then you'll be sentenced to 3 years in the Indiana Department of Corrections with none suspended. And then there'll be an argument related to the credit time you're entitled to. You'll be discharged unsatisfactorily from probation, and judgment liens will be entered for fines, fees, and costs. Is that your understanding of the disposition?
I believe so, Your Honor.
All right, I'm going to ask your attorney to run through the allegations with you.
And Your Honor, before we do that, there probably will not be argument based on some additional documentation with, which is what defense just entered into. So just to make Your Honor aware.
Well, if you have an agreement related to the credit time, I'll be all ears. But before we get to that, let's figure out if we have an admission here. Counsel?
Kevin, I wanted to direct your attention, in this underlying case, you would agree that you read and signed the rules of probation, correct?
That is correct.
And you understood those rules, correct?
Yes, I did.
And you would agree that you violated that probation by being charged with count 1, intimidation, count 2, count 2, harassment, count 3, harassment, under cause number 45 H01 1803 CM 116, correct?
That is correct.
And then there was sufficient probable cause for you to arrest, correct?
Yes.
Also, you submitted a positive drug screen on March 12th, 2018.
Yes.
And at the time of the filing of that petition back in 2018, March 29th, 2018, you were behind $130 in probation, correct?
Yes.
And you agreed that that violated your probation, correct?
Yes.
Also, back on August 16th of 2018, you were charged with possession of methamphetamine under cause number D03
Hi, James.
183, correct?
Yes.
And that also violated the rule regarding illegal substances and narcotics, correct?
Yes.
And you agreed there was sufficient probable cause for your arrest in that matter as well, correct?
Yes.
Now, in September of 2018, you were again charged with intimidation and invasion of privacy under the respective cause numbers 45 HO1 1804 CM 130, 45 HO1 1805 CM 183, correct?
Yes.
And you agreed that there was sufficient probable cause for your arrest, correct?
Yes.
And you had failed to report after being released from the Lake County Jail sometime in 2018, you did not report to probation, correct?
Yes.
Coffee is on the way. I think it's just this guy that has the no mic. I think it gets better in a second, so I'm going to fast forward it to a different person.
Yes.
Well, subsequent addendum.
Very well.
Your Honor, I believe that Ms. Robbins, based on the docket and the records that we access,
Usually numbered A through E.
No, Your Honor.
A through E are admitted. Do you have dates inclusive for me? Okay. You ready? Okay.
August 19th, 2018,
He's driving me crazy with no microphone.
9 to 11.
I'm going to move to the next
What's
one.
accruing right now? On the credit time?
Sure.
Robinson,
Yes, sir.
thank you.
Thank you.
Hopefully, please say the next one is better, please. Can't do a whole
Are you
docket
handling-
like this.
Fabian Perez. State, would you please set a record for Fabian Perez?
Yes, this will be State of Indiana versus Fabian Perez.
Monica, thanks for the
64
cheers. Thank
D01
you.
2006 F5 4297. Defendant appears in person in custody and by counsel attorney Shargaloff, states represented by Deputy Prosecutor Hammer. We were set today for, I believe, also a admission / change of plea.
Well, it's not. It's a disposition of the
Disposition.
probation revocation. Mr. Perez, please raise your right hand to be sworn. Best you can. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, Your Honor.
Okay, thank you. And sir, it looks like I've got a document here with your signature down along the left-hand side. Is that correct?
Yes, Your Honor.
Did you read this before you signed it?
Yes.
One thing that wasn't filled in on my form, blank 2 says a defendant is or is not represented by counsel. Nothing's filled in there. Did you fill something in on that? You signed the rest of them?
I did not.
And what a strike through is not, and put Brown, you mean put Brown? That just recites that your attorney was Mr. Brown.
Okay.
Or in his firm.
Thank you.
So it's my understanding you plan to admit your violation of probation, is that correct?
Yes, Your Honor.
And you'll be sentenced to 86 actual days in the Department of Correction with none suspended. You'll be given credit time from September 29th through today. You'll then be discharged from probation with unsatisfactory designation, and judgment liens will be entered for all your outstanding fees and costs. Is that your understanding of the disposition?
Yes, Your Honor.
You understand if you admit here, you'll be waiving your right to a hearing where the state would have to prove by a preponderance of the evidence that you actually violated your probation?
Yes, Your Honor.
You'll be waiving the right to confront and cross-examine witnesses and use the court subpoena powers to have witnesses brought here to testify on your behalf.
Yes, Your Honor.
With that in place, Mr. Shargaloff, would you please question the
Yes.
client?
Mr. Perez, you recall being placed on probation by this court, correct?
Yes, sir.
And you read and you signed the rules of probation?
Yes, sir.
Tina's got a streak on Twitch. Thank you, Tina. Thank you.
Scheduled off on March 20th, 2024.
Kelly, I'm sorry. That sucks.
Yes, sir.
Additionally, at the time of filing the petition, which was April 4th, 2024, you were behind approximately $410 in probation user fees, along with the court costs that were due knowing and the restitution amount, correct?
Yes, sir.
And finally, you did not complete the SAVE program through the tax office as of March 26th of 2024, correct?
Yes, sir.
And you would
Yes, sir.
and you agree that this violated the rules of your probation, correct?
Yes, sir.
Nothing further, Your Honor.
Okay, I'll accept the admission. Finally, you violated your probation, accept the recommendation of disposition, and send you in accordance with the terms of your agreement.
Thank you, Your Honor.
We're adjourned. Thank you. Let's go with Sherry Shelby. State, would you please set our record?
Good morning, Judge.
Ma'am.
This is State of Indiana versus Sherry Shelby, cause number 64D01, 2406 F3006399. We are here today for a continued consideration of pretrial conference for the defendant.
I can't talk over her because she's too loud. She wins. Linus, thank you so much for the gift membership. Thank you, thank you.
State of Indiana is here by deputy prosecutors and deputy attorney generals Georgiana Typin and Kimberly Savoy. Defendant is here by attorney Shargaloff. I believe she is here in person.
She is.
Yes, ma'am.
And we are still set for a jury trial on January 13th, 2026.
Okay. I show the state's final witness and exhibit list. Were there any motions from the defense?
Judge, there were not at this time. If I could provide the court just a brief status, please.
Go ahead, sir.
Your Honor, we are set for jury trial on January 13th. Ms. Shelby anticipates submission of a plea. However, I think this presents a unique case given her professional licensure. She has retained counsel to deal with the administrative issues, and the plea has been provided to that attorney as well. We're needing some additional time so that she can make sure that the terms for which the Attorney General's office has submitted, the impact that will have on her professional licensure. We do not anticipate moving forward with trial, Judge. However, and I'm sure the state can address this as well, but the state was requesting that the signed plea be submitted, not for consideration today, but a signed plea be placed on file. Given the nature of the signature on the document, Judge, I have concerns about submitting that today. I would ask the court on my motion to vacate that trial setting.
State?
Well, Judge, the state has been told basically from the beginning of the case and the last conversation the state had with defense counsel about the status of the plea that was offered, that was tendered back in July of 2024, was in April of 2025, and the state was told that we were going to be going to jury trial. There have been multiple communications between Mr. Shargaloff and myself, and trial has been on the table, and that's where we were proceeding. And the state has worked very hard getting all of its witnesses secured and served and ready to go, which we are. And it puts the state in a very bad position. The first that I had heard she was still considering even taking the plea was last Monday when we were in court. Prior to that, the state was under the impression that we were going to trial. So now, and that's why the state asked Mr. Shargaloff for a signed plea before the jury trial is vacated, because it's very difficult. We have doctors and professional people that are part of the trial that the state is putting forth who have cleared their calendars, and they are served and they are available to come to trial on January 13th. The state is very in favor of this being resolved by plea, and the state has done everything it can to get that situation resolved. However, there's no guarantee that that plea is going to be taken at this point. So I'm not sure what delaying the trial is going to do after a year and a half of it being on the table, that, you know, she now feels like she can actually take that plea and her license is not in jeopardy because of it. Anyway, that's the state's position. We are not in favor of vacating the jury trial when it's not being set for plea and sentencing today.
Okay. I'll deny the motion to continue the trial, and we will proceed as previously scheduled. What I'm curious to know
Ooh.
is whether we need a motion day or something of that nature or whether you have satisfactory rulings on pretrial motions at this time.
Well, I have not submitted a motion in limine yet. It will be a very standard motion in limine. Um, I've not received anything from the defense as far as discovery or witness lists or anything, so I'm not sure what, Mr. Shargaloff is intending to file. So I would say yes, a motions setting would probably be advantageous for us.
Are you going to use all 3 days of trial?
At this point, I anticipate the state's case being 2 days, so the third day would probably be a safe, just in case there, things run longer than we anticipate. It gives us a little bit of extra time. We may not end up needing the third day, but I think we're safe to keep it on.
I will put a deadline for pretrial motions on January the 2nd. And I really don't have any available time to hear those until the morning of trial.
And that's fine. The state's used to that. So that's absolutely fine, Judge.
Well, I'm becoming more used to it than I want to be, if that makes sense.
I understand.
We will do it that way. And then I won't accept a plea in this case unless it's going to be an open plea to all charges with an argued sentence.
Judge, could we take a brief recess, please? I just, if,
I mean, that was your last case for this morning.
correct.
So if you want to put a pin in this, I'll ask counsel to stay online and we can handle some other matters. You want to go into the anteroom?
I understand the court's position and the Attorney General's position.
All right, Bobby, answer
Again,
her, even though
I don't
Monica
think
already
we're gonna
did.
necessarily to
And then
prejudice
she
my
did
client.
again.
So If I could have a
Understand.
minute to speak.
Okay,
Thank you.
thank you.
Thank you, Judge.
If you can just wait a moment, thank you, ma'am. We'll carry on with some other business. I've got Christopher Edmonds, I believe. State, would you please set our record?
Yes, this will be State of Indiana versus Christopher Edmonds, 64D01-2509 F49779. Defendant appears pro se, states represented by Deputy Prosecutor Hammer. I believe we were doing a Feretta hearing today.
A Feretta hearing. Okay, so we got something, guys. We got a pro se who wants to be pro se. We're going to do a Feretta hearing today to see if he can be pro se or not. I wonder how this is going to go. Here we go.
At a certain point, my screen will populate and I'll be able to talk with you more about your situation. Did you get some information
No,
from us about
Josh.
representing
No.
yourself in court? Did you have a waiver form that I sent out to the jail?
Correct. Yes.
Did you have a chance to review that?
Yes, I did.
Did you sign it?
I signed it.
Okay. Officer Ball, could you bring that forward for me? Thank you, sir.
Officer Ball, can you get that paper for him?
Sir, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth? Okay, thank you. I also got your order in here that terminates the public defender. I'm going to hand that one back to you, okay? Got you. Going back and forth. Thanks. All right, sir, and you're not under the influence of any alcohol or drugs this morning, are you? All right. We haven't set a trial in your case that I know of. Let me just
I'm a little pissed off right now.
get the docket open.
I am court vibes, right? Right? Me? I don't see any of the flag comments. None. Zero. I see 0 comments getting flagged. Shouldn't I see them? I've never seen a flagged comment once on my channel. I'm glad I have mods. Mods, I love you so much. Thank you.
We have not yet been set for trial, but you're indicating you want to proceed pro se throughout these proceedings leading up to trial. You understand that you've got certain defenses that you could present related to the criminal charges against you?
Yes.
Okay, and you believe you have some concept of how to present those to the court?
Sir.
Okay. You understand that if you are convicted here, you've got several charges. Level 4 felony could go for, 2 to 12 years and up to a $10,000 fine. You understand that?
Yes, sir.
A level 5 felony from 1 to 6 years and up to a $10,000 fine. You understand that? And then you have 3 level 6 felonies. Each of those could carry under certain circumstances between 6 months to 2.5 years each, depending on some double jeopardy considerations.
Yes, sir.
And then there's also a Class A misdemeanor there, which could have you for up to a year in jail and up to a $5,000 fine. You understand all that? Okay. You know that at the sentencing, attorneys have a certain skill set where they're able to help the court with mitigating factors and aggravating factors.
Correct.
And they have an understanding of that refined over their course of practice to help the court understand what would be a fair sentence for you based upon your criminal history and such things of that nature.
I understand, Your Honor. If I may,
Go ahead.
I don't think it would ever go that far. I have my driver's license here that shows I reside at that residence where the alleged burglary took place. There's one statement in the probable cause affidavit.
Yeah, Mr. Evans, I don't really want to talk about the merits of the case now. I don't think it's appropriate at this time. What is appropriate, though, is for us to consider the worst-case scenario, which would be that you are sitting in front of me for a sentencing after having been convicted by a jury of your peers, and that the attorney that would have been representing you would have a better understanding of the sentencing guidelines than you might.
I understand.
Okay, you understand that?
Yeah.
All right, and that's what I'm concerned with this morning.
Yeah.
All right. You know that lawyers know how to investigate the case? You have to answer audibly. Can you pull the mic actually towards your face a little bit? Yep. They can interrogate witnesses, they can help find witnesses,
Yes, sir.
and that they're not in jail and they'd have a more freedom of movement and more ability to help prepare for the defense.
Yes, sir.
And you understand that they have a knowledge and understanding of the charges and what might be lesser included offenses.
Yes, sir.
And that because they have that knowledge, they can develop strategy for presentation of the case that might involve, that might result in a more favorable outcome for you.
Yes, sir.
Okay. You understand that they can prepare and file motions. They have an understanding and knowledge of what the court expects related to what those briefs and things in support of their motions should contain.
Correct.
Okay, and you might lack that knowledge based upon your training and work experience, life experience?
Do I lack the knowledge to file a motion? I don't believe so.
Okay, so you feel like you've got knowledge that reaches the same level as a
I
lawyer?
don't want to say the same level, but I know how to file a motion.
And you have sufficient knowledge, you think, to brief that effectively to the court
Definitely, yes, sir.
and to argue that to the court?
Yes, sir.
Okay. You understand that if you're at trial, you would have the same expectations a lawyer would have, and you'd be required to examine witnesses, cross-examine witnesses, and things of that nature?
Yes, sir.
You'd be required to give, if you chose to give, an opening statement. And if you chose to give a summation or a closing statement, you'd be required to do that in front of
Yes,
the
sir.
jury. And you'd have to go through jury selection.
Yes, sir.
Okay. Lawyers also have the ability to work closer with the prosecutor's office, understanding what might be fair in a plea agreement. And that you'll be, if you have the ability to negotiate with the prosecutor, you'll be on your own there.
Correct.
And you might not get as favorable a result.
I understand.
Okay. You know that you won't be given any special treatment
Yes, sir.
if you proceed pro se.
Correct.
You have to follow the same rules that lawyers follow.
Yes, sir.
And you know the state's going to have a lawyer, sometimes multiple lawyers,
Correct. Yes.
and they all have the knowledge and understanding of how these court proceedings would work and how trials work.
I'm familiar. Yes, sir.
And they've been in Mr. Hammer's case in particular through some dozen or so criminal trials, some very significant ones.
I understand.
Okay. Including like serious murder trials and things of that nature?
Correct.
Okay. All right. So you think you have the skills and knowledge that would be helpful to you to represent yourself in these proceedings?
Yes, I do, Your Honor.
You think you have sufficient knowledge of criminal law?
Yes, Your Honor.
You think you have sufficient experience with the criminal justice system?
Yes, Your Honor.
Have you ever had to participate in a jury trial?
I'm sorry.
Have you ever had to participate in a jury trial?
No, Your Honor.
Have you ever been to a live jury trial?
No, Your Honor.
Okay. You think you do a decent job with reading and writing?
Yes.
Think you can speak well in front of people?
Yes, Your Honor.
And you think you have the skills and knowledge to quickly become familiar with large numbers of special rules
Yes, Your Honor.
and procedures?
Correct.
And you understand that the court procedures are a very sort of niche thing, and if you don't do things a correct and proper way, sometimes things won't go like you would expect them to go?
I understand.
All right. And there's been no promises from anyone or any suggestion that you'll receive special treatment or a milder sentence if you represent yourself, correct?
No, no, no.
And no one has threatened you or offered any sort of disadvantage or harm to you if you represent yourself, correct?
No, Your Honor.
Okay, well, I mean, based upon your assertions, I'm going to file mark this, make it part of our record, and allow you to represent yourself pro se. You had at the top of this Brady motion for evidence.
That's, excuse that, please. That was just,
You want me to white it out?
please.
Okay, I'll
Thank
take it off there. I didn't know if you needed that note for what you plan to do next or not.
No, sir.
Judy, I've made so many mistakes that this thing is empty. Assuming we have more. All right, I can keep on making mistakes. All right, so Mr. Edmonds will be proceeding pro se and without counsel. There was a motion for fast and speedy trial that came before the court on December the 4th. Mr. Hammer, did you have a opportunity to read that? I apologize. I got one on the 4th, but at that time you're still represented by counsel.
Correct.
I got another one on December the 19th that I will consider today. This is actually a combined motion. One is for the fast and speedy trial. So let's get that on the calendar. From December the 19th. Often I'll have notes. I don't have any here. I would suggest we do this on February the 10th. How many days do you need to try it?
Your Honor, I should need 3 days.
3 days? So we'll set trial by jury on February the 10th, starting at 9 a.m. I'll have you come back on the 12th for a pretrial conference at 9 a.m. All pretrial motions and things will be due before that, January 12th. We'll have our regular trial setting. Is there video in this case?
There will be, Your Honor.
Okay.
Probably body cam at best.
Okay, you better get it over to them.
Yep.
Probably before the end of the week,
Yes, Your Honor.
so you can start working on redactions if necessary. How long is it?
Your Honor, I don't know how long it is off the top of my head, and I don't want to
Okay,
mislead the court.
okay. Do you think you'll have any video evidence?
The body camera footage as well, Your Honor.
Okay. But it's the same body cam footage, correct?
Yes, sir.
All right, so I've ordered the state to get that to you by the end of this week.
As well as dash camera footage from the transporting officer, Your Honor, please.
So you say you did a FOIA request?
Yeah, yes, sir. I've sent
Your
out.
motion here, a FOIA request won't do anything for you in this court.
Okay, thank you.
You're under a different set of rules here. Discovery rules have nothing at all to do with FOIA, just so you're conscious of that.
Thank you, thank you.
But the state does have a requirement to present you with all of their evidence. It's that Brady thing that you mentioned on your note to yourself. So they'll have to get all their evidence over to you. Was there already production made to prior counsel?
Yes, there was, Your Honor, as well.
Did your attorney give you their file before they left the case?
No, sir.
Okay, state, get them discovery too by the end of the week.
I just made a note to do it all regardless.
Appreciate it. And that will include all the videos they have in their possession.
How do I go about viewing the video footage while incarcerated?
Sounds like an issue, not an ish me. But there's a good chance the library at the jail has video viewing capability that you'll be able to,
Sounds like an issue, not an ish me.
work with the warden or somebody at the jail to play those videos.
Thank you.
On a camera, or I'm sorry, on a computer they have available there.
Thank you. Your Honor.
Okay? I think that covers it for today.
Yes, Your Honor.
We'll see you back on January the 12th. If you don't see what you think you should have before the new year, you should write me another letter,
Sir,
okay? And I'll look at that as soon as I have it.
appreciate it.
But we'll see you back January the 12th at 9 a.m. and then jury trials on February the 10th at 9 a.m. I mean, you asked for the jury trial, but I'm going to give you this advisement anyway. If you fail to appear at your jury trial, I'm going to hold it in your absence.
Hell yes, I'm clipping
I
that.
understand, Your Honor.
1
Something
hour,
else you need to be
54 minutes
concerned
in.
with is making sure you have clothing for the trial. It might be a little bit of an issue. I'm not sure who your folks are or where they are, but you want to get clothing ready so you don't have to stand there in that jumpsuit.
Yes,
Talk to
sir.
the jury.
Thank you, thank you.
Okay? So we'll see you back January the 12th. Anything further state?
No, Your Honor.
We're adjourned.
Oh, I hope I get him on January 12th.
Mr. Theros, you have Tanisha Barrett. State, would you please set our record?
Yes, this is State of
When can you
Indiana
pay?
versus
It's a
Tanisha
30
Gareth, 64 D01 2308 F6 7549. Defendant appears with counsel attorney Theorist. State is represented by Deputy Prosecutor Hammer. We were set for sentencing today, Your Honor.
Okay. Anything on the pre-sentence report, State?
No, Your Honor.
Anything on the pre-sentence report, Mr. Theros? Can you grab that mic and,
Yes. Your Honor, the one issue that we identified as being deleted or corrected, Judge, would be, I'm on page 12 of 13, Your Honor. Up at the top, Judge, in the areas of I'm looking at the paragraph which begins areas of concern are the defendant's criminal history. And continuing on toward the end of that sentence, a do unto others before they do unto you mentality. My client disputes that she made such a statement to the probation judge, and I, reviewing that, other portions of the report, attitudes and behavior, I don't see that my client ever made such a statement to probation. So I don't know if probation felt that maybe their assessment of Tanisha at the conclusion of this interview was that she had such an attitude, but she denies having such an attitude, Your Honor.
yeah,
You're-
I'm surprised Mr. Ringer's not here.
Probation just wrote that down for fun, I
think that's
guess.
just the golden rule being recited, not a direct quote of defendant. Is how state reads it. It's not a
I
quote
didn't
from.
ask the state for their position. I'm perfectly capable of
Yeah.
analyzing this language and the words that were used by our report writer to reach my own conclusions. But certainly, I think that it's not Mr. Ringer directly quoting her. It's Mr. Ringer paraphrasing the golden rule to suggest that in his interactions with Ms. Barrett, that was what he got from her, right? Was that that's her attitude, that that's the way that she suggests she should handle matters, in a preemptive sort of way, if she feels threatened or something of that nature. So
It was the
I'm
presence.
happy to strike it. I
it-
don't know that it adds anything to the discussion there.
Very well, Your Honor.
Okay.
Your Honor, then.
Because I think a lack of empathy towards others probably gets the message across, you know? But I'll strike the "and do unto other before they do unto you" mentality phrase.
It was the presence of the quotation marks
I understand, sir.
all right, Judge.
Yep.
Your Honor, on 11 of 13, personal health attitudes and behavior, sub A, physical health, the defendant, she did self-report some medical concerns, Your Honor. But ultimately, I believe with respect to cervical cancer, kidney issues, it's more of she was recommended to have a hysterectomy. And I apologize, I should probably not be doing this in open court like this, but it was not really kidney issues as much, it was perhaps something else, Your Honor.
Okay.
I apologize for reciting that here in open court. Beyond that, Judge, no other corrections or deletions to the pre-sentence report.
Okay. Yeah, so for the 7A information duly noted, there's just a little bit of a nuanced understanding by our writer there, but there could be a health issue. But I don't know that that has any bearing on sentencing either today. But with those things in place, anything else on the pre-sentence report?
Not by way of additions, corrections, or deletions, Your Honor.
All right, thank you. And then state, anything for the argument, anything, evidence or argument for sentencing?
No, Your Honor, I believe restoration court would still be, given her background and my understanding of her, I would believe it's fair and appropriate. Your Honor, my only question is, I don't see where a no contact order was ever issued.
Now, if that's the case,
Maybe we missed it, but I never saw that a no contact order was issued, because usually in the cases where it's a officer,
they don't do a no contact order, so I'm not sure how they're
seeing one unless it was the 10-day.
Well, the report writer says he doesn't see a no contact order, but there's one referenced in the plea
Oh.
agreement.
Gotcha.
There isn't one, Your Honor.
Okay.
I thought I misread that the wrong way. I thought he saw one and there wasn't one.
Okay. There's also a concern from a report writer about whether it's count 3 or count 4. And there was an active effort to redact subsection 4A before the plea was taken.
It would have been count 3, Your Honor. I have a note that we addressed that last time in court.
Okay.
I don't know if it ever made.
So in subsection 4D, it should also be count 3.
Correct.
That's what he says there. All right. Anything else, any evidence or argument, State?
No, Your Honor.
Evidence or argument, Mr. Theros?
Only argument, Your Honor.
Go ahead, sir.
Judge, we asked the court to accept the plea and a recommendation for the restoration court. There was a correspondence, hopefully the court has received it where she was found acceptable for restoration court. The pre-sentence report, Judge, has,
Nobody gave that to me, and it hasn't been filed in the case. Do you have a copy?
yes, Your Honor, may I approach?
Yes, sir. Just extra?
That is for the courts to keep.
Okay, you don't need me to burn one?
No, Judge, I have a copy for my file.
Okay. Thank you, sir. Perfect. Yes, I don't know. what else
Oh,
is on the file,
yes. Lots of butter. Yeah. Yeah.
But alas, I have it now.
Thank you, Judge. She has a history of mental health, Your Honor, that the restoration court, I believe, would be appropriate for Ms. Barrett. Although she has in the past had some difficulties with probationary sentence, there are many instances in the report where she successfully completed probation. So I think that she has the ability to, Your Honor, I believe she has the desire, willingness to get into this program and complete. And I believe it would be in her best interests. And I'm asking the court to accept the recommendation for restoration court and afford her that opportunity. Thank you.
Thank you, sir. Ms. Barrett, this is your chance to say whatever you might like to say before I rule on the case. Would you like to exercise that right?
That I know that I have mental issues. And I know sometimes that when I don't have take my medication, I make bad decisions. But my mental issues kind of deter me. But I do take my medication as I'm supposed to, and so I would like to have that, please, restoration court.
Okay, Ms. Barrett. Thank you for your statement. At this time, the court will accept the recommendation of plea negotiation. Pursuant to that, well, am I entering conviction or am I taking conviction under advisement pending completion of the program?
It would be under advisement, Your Honor.
All right. So pursuant to that, I will take pleas of guilty under advisement in F6-7549, count 1 battery, a level 6 felony, and in F5-11486, count 1, possession of methamphetamine, a level 5 felony, and count 3, operating while intoxicated, a class A misdemeanor. And then if you're successful,
Monica, thanks for the
the
cheers.
state would
Thank you.
dismiss all the charges in this case, I believe.
Correct, Your Honor.
If you're unsuccessful, the restoration court will return you to me for an argue sentence.
Shelley.
And then you'll be sentenced pursuant to my discretion. And that's only on those 3 counts I suggested. The remaining counts would all be dismissed.
Yes, Your Honor.
This sentence would allow you 5 actual days time served from August 24th through August 28th of 2023. And that's for short cause F6-7549. And then there are 6 days from December 15th, 23 through December 20th, 2023 in F5-11486. And there are $31 in pretrial supervision fees. In F5-11486, sorry, Judy, the counts 1 and 3, The sentences will be concurrent. And it doesn't say this, but by operation of law, sentences for F67549 and F511486 must be consecutive. So do you understand all that? Okay. So your agreement is that concurrent in F511486, the law says that for the other case, I have to make them consecutive if you get returned to me for sentencing. Okay? I don't expect that's going to happen.
No, I'm gonna complete it successfully.
This is a difficult program. You understand that?
I have to,
This restoration court program is going to demand a lot of your attention,
yes.
right?
And I don't have nothing but time, because I don't do anything.
But the most important thing it's going to ask you to do, Ms. Barenth, is to continue and stay current with and be compliant with your treatment with your doctor.
Yes,
Okay? And there's going to be a whole team of folks there to help you stay compliant with your treatment. Okay?
at the restoration court.
At the restoration court. And if you ever feel like you need more help, talk to your case manager, talk to your caseworker. You work with Porter Stark for your medical treatment?
No, I do not. I go to Edgewater in Gary.
Okay. Do they have a case manager appointed for you?
I have a therapist I talk to.
You have a therapist?
Mhm.
Do they have a peer counselor that helps you at all?
I just have my therapist counsels me,
Okay.
my psychiatrist, and then I see my counselor, my therapist. That's it.
Sometimes peer groups can be helpful, especially if there's a dual diagnosis for addiction and mental health. The peer counselor is a person who's been through this before, right? So if I were you, I would take a note for yourself when you're in restoration court, ask them for a peer as well. Okay, so you have somebody you can reach out to if you feel like you need additional shoring up. I'm gonna send you over to the jurisdiction of the restoration court. You should stop by there and make sure they know when to expect you. And I
Okay.
think it'll probably be at their next regularly scheduled court at the beginning of the year, Counselor.
Okay,
Okay?
I don't, and will you come back?
Yes, Your Honor.
Okay?
When do I have to go?
I lost you. Good luck to you, ma'am.
Thank you.
We're adjourned.
Your Honor, one final matter, housekeeping.
Denisha, I hear what you're saying.
I realize that the pleas have been taken under advisement, dismissal, there is no disposition of these matters at this point in time. I did previously file a bond assignment. Is the court addressing bond at this
I'm
point
sorry,
or at a
Denisha.
later date?
Yeah, I won't address the bond assignment until the case is complete.
Yes,
For
sir.
better or for worse.
Understood, Your Honor.
Okay? Thank you.
Thank you.
Ms. Bond, you have a matter for Jediah Sims?
Yes.
State, would you please set our record?
This is State of Indiana versus Jada Sims, 64 D01 2510 F51140. Defendant is present with counsel attorney Bond. State's represented by Deputy Prosecutor Hammer. I believe we're going to go through with the change of plea today.
Sorry, Your Honor. One moment.
Jada, I have no idea where the extra syllable came from. I called you Jedediah or whatever I said, but
Got you. Yep.
welcome.
You're fine. I've had people call me that all the time.
If people have butchered it worse than that, then I'm in good company, I guess.
You tried, Judge.
All right, how can I help?
Your Honor, we do have a change of plea. I don't see that it was accepted on Odyssey, so I give.
It was tendered here.
It is? Okay,
Yeah,
great.
they must have just grabbed it
Okay, great.
within the last couple hours. You ready to proceed with that? Ms. Sims, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. And please state your full name for the record.
Jada Sims.
What's that middle name?
Oh, and Brianna. Sorry.
Okay, Ambriana.
Yeah, Jada and Brianna Sims.
How old are you?
30.
Have you ever gone by any other name?
No.
Court has been informed that you wish to change your plea to guilty on count 2, domestic battery, a level 6 felony. Is that correct?
Yes.
Before I can accept any guilty plea, I need to ask you some questions. But anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be allowed to do that. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability? And it's not a gotcha. I read the rest of your plea here. What I'm really concerned with knowing is whether any mental health condition impacts your ability to understand today's proceedings.
Oh, no, I just have like anxiety and depression, but that's about it.
Okay. Does it impact your ability to work with your attorney?
No,
In the course of you going through the recommendation of plea negotiation, the document itself, did it hamper your understanding of that document?
no,
Okay. And are you currently under the influence of any alcohol or drugs?
no,
Ms. Sims, to count 2, domestic battery, a level 6 felony, how do you now plead?
guilty.
Ms. Sims, you have the right to a public and speedy trial by jury. Do you understand that?
Yes,
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those witnesses. Do you understand that?
yes,
You have the right to require witnesses to be present at any hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. Do you understand that?
yes,
State of Indiana must prove beyond a reasonable doubt that you committed the offense charged before you could be found guilty of that offense. You understand that?
yes,
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
yes,
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
yes,
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
yes,
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. Do you understand that?
yes,
By pleading guilty, you're admitting that everything the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
yes,
And by your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
yes,
The possible penalty for a level 6 felony is from between 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
yes,
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. Do you understand that?
yes,
Are you currently on parole or probation anywhere?
no,
Other than this case, are you out on bond on any charges anywhere?
no,
This plea of guilty may cause harsher sentences for any future crimes. You understand that?
yes,
The court received a 4-page document entitled Recommendation of Plea Negotiation. The document appears to bear your signature about halfway down on the 4th page. Did you sign this agreement?
yes,
Did you read it before you signed it?
yes,
Did you have a chance to speak with Ms. Bonds before you signed it?
yes,
And before you signed this, do you believe you understood its contents completely?
yes,
As I understand the sentencing portion of the agreement, you'll be sentenced to 730 days in the Indiana Department of Corrections, suspended. You'll receive credit for your time served, and you'll spend the balance on formal probation. You'll undergo mental health counseling as a condition of probation. You're responsible for the payment of all associated fees. You'll sign all releases necessary for the court, probation, and state counsel to be able to monitor your compliance. If you successfully complete probation without violations, you may petition for Class A misdemeanor, and the state would reserve the right to object to the request. Obviously, I would retain discretion over that. You'll pay the criminal offense mandatory fee, which is a $50 domestic violence prevention and treatment fee. There's a no contact order that was entered as a condition of bond that would be terminated at the time of sentencing. Is that your understanding of the
I know the
agreement?
lady
Yes.
closest to us
I mentioned you received credit for
who's facing this way. She's a lawyer. She talks every once in a while. Crystal clear audio.
your time served awaiting disposition of this case. You understand that?
yes,
You know, that I'm not a party to this agreement, but I'll be bound by its terms if I choose to accept it.
yes,
And I'll be bound by it at your sentencing and with respect to any potential future sentence modification.
yes,
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
no,
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
no,
Your attorney's going to ask you some questions to establish what we call the factual basis for your plea. If you give her your attention. Ms. Bonds, are you prepared to set our factual basis?
yes, Your Honor.
Bless you.
Thank you.
October 12th, 2025. You residing at a home in Beverly Shores, Indiana?
yes,
And at that time, were you residing there with your father, Wendell Sims?
yes,
Did your children also reside there?
yes,
And on that date, was there an occasion where you struck your father, Mr. Sims, on his left hand in what would be considered a rude, insolent, or angry manner?
yes,
And at the time when that occurred, were your children present in the home?
yes,
And do you agree that your actions were contrary to the Indiana Code?
yes,
And this all happened, Beverly Shores is in Porter County, Indiana, is that correct?
yes,
Judge, I have nothing further.
State?
I would just ask the probable cause be admitted for any further factual as it relates to the pled count.
Oh, also that admitted insofar as it applies to count two. I don't have any additional questions. Court finds the defendant understands the nature of the charge against her to which she's pled guilty, that she understands the possible sentence for that charge, that her plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. We're moving into sentencing, State?
Your Honor, we can, yes.
Okay, we'll show waiver of the pre-sentence report. Any evidence or argument for sentencing, State?
Your Honor, she did have a prior, at least an open case for domestic back in 2019,
Which is why we've started with the pleading it as a level 6 felony based on what's here, Your Honor, but also giving her a misdemeanor the chance to reduce it to a misdemeanor in the future. As we've also discussed with the victim and been able to make contact with him about after getting some clarification that he was willing to terminate the NCO, at least as it comes to this, which I do have a copy of this, Your Honor. And he believes that this will, with the mental health component and all of that, it gets addressed the issues that the victim saw as well, Your Honor.
Thank you. Counsel?
And Judge, so as Ms. Sims said, she is 30 years old. She is the mother of 2 children. They're 8 and 9 years old. As a result of what occurred here, she did spend 3 days in custody. She also has not been able to have any contact with her children. They're also a part of the no contact order. This has had a significant impact on Ms. Sims. It's had her come to realize really the gravity of her actions and driven the desire for her to take steps to be better for her children and her parents. She's already begun to seek behavioral counseling, so she's done the necessary steps. She's gotten those things in place. I think she will be successful here. I think that, you know, especially with her willingness to address the issues that she has, she definitely wants to put herself in a position where she'll successfully complete the probation and come back and ask for to amend this down to a misdemeanor. She has been working throughout this time. She just was promoted to manager at Qdoba. Judge, we asked you all along.
Okay, yeah, thank you. I was just going through, I don't see any other pending case, but she said yes to, she's on probation somewhere?
No, she's not. This was from, I believe, 2019.
The case downstairs?
Yeah.
Okay. Okay. Ma'am, is there anything you'd like to say?
I'm sorry. I think there was a PDP entered in that case, if I'm not mistaken.
I think it's done. Yeah. Anyway, ma'am, is there anything you'd like to say before I rule on the case?
Your Honor.
Okay, that's fine. Well, at this time, the court will accept the recommendation of plea negotiation. Pursuant to that, enter judgment of conviction on count 2, domestic battery, a level 6 felony. Dismiss count 1 and count 3. Sentence you to 730 days in the Indiana Department of Correction. Suspend that. Balance on formal probation. You'll undergo mental health counseling as a condition of probation. Be responsible for the payment of all associated fees. Sign all releases of information necessary for monitoring. Upon successful completion of probation without violations, you may petition for Class A misdemeanor treatment. State reserves the right to object. You'll pay the criminal offense mandatory fee, which is a $50 domestic violence prevention and treatment fee. And I will terminate this no contact order. There was a cash bond posted in the case. From the cash bond, the court will retain court costs, probation initial administration fee, jail booking, sheriff's death benefit fee, the $50 mandatory fee. The remainder, I have a bond assignment. signed by Jada. I have a bond form, however, countersigned by Jacqueline Walker. So Jacqueline Walker hasn't signed your bond assignment. You want 5 days to get her signature on it?
I can do that. Sir.
Okay.
President in court, I don't know that.
Jacqueline Walker, are you here? Jacqueline, is it your intent that the remaining bond money be paid over to Ms. Bonds? Okay, on the assertion of Ms. Walker in open court, we'll pay the bond money over to counsel on the bond assignment that was previously filed. Just note for the future that when it's, because that's her money,
I will.
according to the statute on bonds now. So, all right. And then, Jade, I wish you the best of luck. I need you to go from here to the probation department, get started on probation, and their office is at 157 Franklin Street. Okay, just outside the courthouse. Veer left down the sidewalk, half a block down on the left-hand side in the old jail.
Okay.
Okay, were you on pretrial? No? Okay. Yeah, you'll find it. There should be somebody in there.
I'll direct her.
All right, anything further than counsel
No, you're.
for the state of Indiana?
Yes, Your Honor, just the Brady disqualification, because it's a domestic, I think we have to go.
Well, I don't have to say anything. There is going to be a domestic violence determination that'll be entered by the court. You'll see the domestic violence determination, and that makes you what's called Brady disqualified. Brady disqualification means that you can't possess a handgun. You also can't buy a handgun, right? So if you try to buy one, they're going to shut you down at the store.
Okay, I don't even want a gun, so it's okay.
I just want you to know, some people like to go shooting. And with that, anything else?
No, Your Honor. that
Okay,
was-
thank you.
Thank you, Judge.
We're adjourned. Hey,
Thank
you
you.
too. Thanks so much. Thanks for your patience this morning. What say you, Mr. Sharkey?
Mr. Shargaloff, we can't hear you.
Ms. Shelby, I think you should come up if we're going to do a plea. You want to approach with that? Okay. Okay. Ms. Shelby, please raise your hand to be sworn. Do you swear, affirm under penalty of perjury, to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. Please state your full name for the record.
Sherry Lynn Shelby.
And have you ever gone by any other name?
Yes, I've been married before.
What was your other name, ma'am?
Sherry Witten,
Okay,
Sherry Stram,
okay,
Sherry Gordon,
okay,
and Sherry Marino.
okay,
I've been married 4 times.
okay. How old are you?
I am 58 as of last week.
The court has been informed that you wish to change your plea to guilty on count 1, neglect of a dependent resulting in serious bodily injury as a level 3 felony. Is that correct?
Yes, sir.
Okay, before I can accept any guilty plea, I need to ask you some questions. Anytime you don't understand a question, let me know and I'll explain. Anytime you'd like to speak with your attorney before answering, let me know and you'll be permitted to do that. Have you ever been treated for any mental illness or do you now suffer from any mental or emotional disability?
No,
Are you currently under the influence of any alcohol or drugs?
no, sir.
To count 1, neglect of a dependent resulting in serious bodily injury, how do you now plead?
Guilty.
Ms. Shelby, you have the right to a public and speedy trial by jury. Do you understand that?
Yes, sir.
You have the right to face all witnesses against you, to see, hear, question, and cross-examine those
Hell
witnesses. You understand that?
No,
Yes, sir.
Monica.
You have the right to require
No.
witnesses to be present at
No
any
way.
hearing or trial to testify on your behalf, and the court will assist you in exercising that right by issuing subpoenas. You understand that?
Yes, Your Honor.
State of Indiana must prove beyond a reasonable doubt that you committed the
I'd be in
offense
jail,
charged
too.
before you could be found guilty of that offense. You understand that?
Yes, sir.
You cannot be forced to make any statement or to testify against yourself at any hearing or trial, but have the right to remain silent. Do you understand that?
Yes, Your Honor.
If you were to have a trial and were found guilty, you would have the right to appeal your conviction to the Indiana Court of Appeals. Do you understand that?
Yes, sir.
By pleading guilty, you're giving up all of the rights that I've just gone through. You understand that?
Yes, sir.
You have the right to be represented by an attorney at all times, including trial and appeal. If you cannot afford to pay for an attorney now or at any future time, the court would appoint one for you. You understand that?
Yes, sir.
By pleading guilty,
Same,
you're
RW.
admitting that everything
Same.
the state would have to prove beyond a reasonable doubt for you to be found guilty is in fact true. You understand that?
Yes, sir.
By your pleading guilty, the court will proceed with judgment of conviction and sentencing without a trial being held. Do you understand that?
Yes, sir.
The possible penalty for a level 3 felony is from between 3 to 16 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, sir.
If you have any previous criminal convictions or previous juvenile delinquent adjudications, those may cause an increase in your sentence, or they may prevent the court from suspending part of your sentence. You understand that?
Yes, sir.
Are you currently on parole or probation anywhere?
No, Your Honor.
Other than this case, are you out on bond on any charges anywhere?
I hope you do too,
No, Your Honor.
Martha.
Okay, this plea of guilty may cause harsher sentences for any future crimes. You understand that?
I don't know what
The court received a 3-page document.
time my plans are on Christmas. What I'm doing on Christmas. I know I'm going to a buffet. That's all I know. There's a good chance I'll be doing a live stream Christmas night for anyone who is, you know, otherwise not occupied and just sitting at home on Christmas. We'll see. I probably will. It's better than not chance. It depends what time I go to that buffet. And if it knocks me out, if I eat so much that I can't move.
Entitled, well, it doesn't have a title. Appears to be a recommendation of plea. It appears to bear your signature on the 3rd page. Did you sign this agreement?
Yes, sir.
Did you read it before you signed it?
Yes, Your Honor.
Did you have a chance to speak with your attorney before you signed it?
I did.
And before you signed this, do you believe you understood everything contained within it?
I believe so.
As I understand the sentencing portion of the agreement, you'll be sentenced to 6 years. in
Christmas
the
is
Indiana
extra
Department of
hard for some
Corrections,
people.
all suspended.
Not fun.
You'll spend 4 years on reporting probation through the Porter County Probation Department. So that's formal probation. You may petition to terminate probation after 2 years served with no violations. Court costs, you'll be responsible for court costs and fines. Is that your understanding of the sentence?
Yes, sir.
You understand you'll receive credit for your time served awaiting disposition of the charges?
Yes, sir.
You understand I'm not a party to this agreement, but I'll be bound by its terms at your sentencing and if there's any future sentence modification?
Yes, Your Honor.
Have you or anyone else received any promises or been given anything of value to cause you to enter this plea of guilty?
No, sir.
Has anyone forced or threatened or placed you or anyone else in fear to cause you to enter this plea of guilty?
No, sir.
Your attorney's going to ask you some questions to establish what we call a factual basis for the plea. If you give your attorney your attention. Mr. Shargaloff?
Thank you, Your Honor. Sherry, I'd like to direct your attention to a time period between July 18th of 2023 and July 19th of 2023. On a particular date, between those dates, were you present here in Porter County, Indiana?
Yes, Your Honor. Yes, sir.
And you were present here as you had the care and responsibility for Kevin Klusmeyer, correct?
Correct.
And Kevin was a client or a patient of yours who was being transported from East Chicago over to Porter County, correct?
Correct.
And you voluntarily assumed the duty to care for him in that transit, correct?
Yes.
Now, during the course of that transit, Sherry, Kevin became, shall we say, difficult to deal with, correct?
Correct.
And you would agree that then in that time, you gave him some food, correct?
A donut.
And there were no issues up until the point where you came to Opportunity Enterprises here in Porter County, correct?
Correct.
All right. And at that time, you engaged in life-saving measures for Kevin, correct?
Yes.
All right. But during the course of that transit, when you administered the donut, you would agree that you knowingly or intentionally administered the donut, correct?
Yes.
There. Now, Kevin ended up choking on the donut, correct?
Correct.
Which caused other complications, Sherry, that led to his eventual death, correct?
I believe so.
Okay. You would agree that the administration of that donut placed Kevin endangered Kevin to a point where his life or health was jeopardized, correct?
I don't understand.
One more time, Sherry, I'm sorry.
I don't get it.
Yes, I,
Fine. Counsel?
Oh no. Oh no. I only
For the state,
bumped forward one minute by
any
accident.
additional,
I don't understand. I don't understand. Oh, now I understand. Now it's about to become clear. We'll start right here. We'll see. This is why she's in trouble for giving that kid a donut. This is why she's in jail or whatever.
any additional questions?
Miss Shelby,
yes, ma'am.
Kevin was on a doctor's order for a pureed diet only, correct?
Correct.
And you were aware of that, correct?
After the, yes, after the fact, I was made aware of it.
Are you saying today that you did not find out about Kevin being on a pureed diet until after this happened?
Correct. While I was sitting in the emergency room, talking to the nurse consultant is when I found out that he was on a pureed diet. And my heart fell.
If I could have a moment, Judge, please.
We all need a moment. We all need a moment. She gave this child a donut and the child died. Now she's going to jail.
Ma'am, you were the health facility administrator of Harbor Health, is that right?
Yes, ma'am.
You were in charge of the facility, correct?
Correct.
And as such, you had weekly meetings regarding your facility and regarding the patients in your care. Is that fair?
That would be lovely.
I mean, yes.
Yes. And part of those weekly meetings involved multiple discussions about Kevin and his inability to handle solid foods. Correct?
Most of our conversation at the meetings were about his behaviors. And, oh, no, I'm sorry.
I believe I have nothing further.
I don't see a law that was broken here. Did anybody see
Okay.
a law that was broken?
Never seen me pick this book up before, have you?
You've never seen me pick this book up before, have you? The judge is flabbergasted. The judge is just like me right now. What in the hell is going on? What are we watching? I don't understand. The prosecutor couldn't even ask an additional question. I want to scroll to the end of the transcript and see what happens here. I feel
Elisa.
like they're gonna convict her anyway. That's what I feel. I don't
Yeah.
know.
I might ask one more follow-up question. I think that might clarify this a little bit.
You can go ahead.
All right. Sherry, regarding the orders from the doctors from his treating physician, that he be on a pureed diet, you would agree that in your capacity, not only as the administrator, but also as the nurse who was providing the transportation for Kevin, you knew or should have known what was contained in his charts. Is that a fair and accurate statement? In that particular role?
Got it. She's the nurse. So, nurses are supposed to look at the chart, right? Follow the chart. She gave him a donut. The chart said puree diet only. Now it makes a lot more sense. It sucks. It sucks. The whole thing about this sucks. But that's right there is why she's sitting in jail or wherever she is. That sucks. This is terrible.
Yes.
Okay, I was just reviewing the statute. I think that you've found a sufficient factual basis here. I don't have any additional questions. Court finds the defendant understands the nature of the charge against her to which she's pled guilty, that she understands the possible sentence for that charge, that her plea has been made freely and voluntarily, and there's a basis in fact for the plea of guilty. Court will take final acceptance of the plea of guilty and approval of the plea agreement under advisement pending receipt of a pre-sentence report. And I'm happy to do sentencing on the 12th of January because I can't do it on the 19th.
That's shitty, Mel.
So, counsel, do you want to be present for the sentencing?
I would like to be present for the sentencing, yes, please.
Okay. So I'm looking at February the 2nd or 9th. Ms. Shelby, your counsel's indicated that you're willing to waive your right to be sentenced within 30 days. Is that correct, ma'am?
Yes, sir.
You join with him in that waiver?
Yes, sir.
Okay, thank you.
9th, please, Your Honor.
Say again?
9th, February 9th.
Yeah. I want to see what, I've only got 10 because I already have a 11 a.m. argued sentence.
That time works.
We can't waive PSI.
Can you be here on February 9th at 10 o'clock, ma'am? Ms. Typen?
Oh, I'm sorry, Judge. I thought you were talking to Ms. Shelby. Yes, I can be there on February 9th.
Okay, we'll see you at 10 o'clock. Ma'am, I'm going to set your sentencing over with the waiver February the 9th at 10 a.m. Your order to appear. Need you to go from here to the probation department, 157 Franklin Street, and get signed up for a pre-sentence investigation. They'll do an
Okay, she's
investigation,
not in
prepare a
jail.
report for me that I can have available at your sentencing hearing. Do you understand?
Yes, sir.
Okay, we'll see you back on the 9th of February, and I will vacate the trial that is set in this matter, and any other hearings that we had on the calendar will be vacated as well.
Thank you, Judge.
We're adjourned. Thank you.
Thank you, Judge. Have a good holiday.
Have a good hot. You have a good hot too, prosecutor. Oh, guys, thank you so much for coming out today. I'm going to set up OJ, and we're going to have fun in OJ. Oh, gosh, we're getting closer. And I shall see you all again very, very soon, probably in 22 hours. Behave today. Remember to make sure you're really nice to people. People are stressed out this week. Be nice. Just say something nice. It's all you got to do. And if you're driving, I'm sorry, all you have to do is follow the traffic laws this week. No U-turns, no trying to shove yourself in. You follow the traffic laws and everybody will be happy. You thinking you're the only car in the road is what gets people pissed off at Christmas. They're already stressed. Just, if you're in the wrong lane, eat it. Go around the block. Don't shove yourself in. Just follow the traffic laws. I think if everybody drives lovely this week, the stress level will go down very far, because driving sucks this week. I hope some of you get snow. I hope if you don't want snow, you don't get snow. I hope Pennsylvania gets covered. I do. So if you're in Pennsylvania, sorry, I love snow. That's why I live in Pennsylvania. If I don't like snow, I would move to Florida with Bill. I would be Bill's neighbor, and I would grow a bush that looked like a big middle finger. And he would have to look at that every day. I would, and I would laugh every day. And he would say, Kathy, cut that down. And I would say, boo. I love Bill. I love Bill, though. I love Bill. All right, guys, I'm going to start OJ. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,